Hello, ladies and gentlemen. My name is Mike, and today we're once again here with Zack from the Hendon Law Firm to talk more about workman's compensation. And today we're going to focus on what we should do. So let's dive into this. But first, there's a disclaimer. We need to let you know that this is for informational purposes only. Zack is an attorney with over 30 years experience and provides this information to help you, but it cannot be considered legal advice. For legal advice, you'll need to consult with an attorney near you. If you're in the Metro Atlanta area, please give the Hendon Law Firm a call. They would love to sit down and talk with you. Zack, welcome to the show.
Oh, thank you, Mike. Glad to be here.
Well, today we're back again. We're going to talk about workman's compensation, but today we're going to talk about what we should do if we're injured, all that. You ready to dive in?
Let's dive in.
So, Zack, I've been injured. Should I report my injury? And if I don't report my injury, what happens?
Well, you do need to report your injury. A lot of workers are very conflicted about this because the employer talks out of two sides of their mouth. On the one hand, they tell you in training that you must report any injury right away. Okay, well, I know that in a lot of these manufacturing jobs, people are getting injured to some extent every day. They're getting, cuts on their fingers. Sometimes the injuries are small. And all the workers know that if they actually did report every injury right away, they would be fired by the end of the day because the supervisor would be going, you're making a mockery out of this. And so typically what the employees will do is they'll try and gauge for themselves, did I have a serious injury or not? And they don't want to, they're job scared and they don't want to report injuries that, are not significant. But on the other hand, what if this injury that you thought was just going to last a day, like you think it's just a back strain, and it turns out to be a herniated disc that you need a fusion surgery for? So the worker's in between a rock and a hard place. But in general, you are supposed to report your injury, right away. The employer wants to say right away. The law doesn't really require you to report it right away. The law says that you have to give the employer 30 days notice in which to report the injury. Now, the problem with that is even if you have 30 days notice, if the employer then suspects that you were really hurt over the weekend, let's say you wait 2 weeks to report it, many times they're thinking, well, you didn't tell us right away because you really weren't hurt there. You were hurt over the weekend, and then they'll controvert the case based on that, and then they'll try to find evidence, to support that, which could delay your benefits and, cause you problems. So the best answer to that would be to go ahead and report your injury right away. If you don't, it doesn't kill your case. It might make your employer suspicious, but the law says you do have to report it within 30 days or your claim could be barred.
Okay, but reporting your injury doesn't mean you're filing a claim, does it?
No, not necessarily. If you do not need medical treatment or you're just giving, basically what you're doing, you're just giving your employer notice that something has happened so that they can be on, that they can do their due diligence if they need to see if this was something that happened at work. You may still be working. You may not even request medical treatment, but it just gives the employer a notice. And sometimes it's not even, the notice requirement's pretty loose in Georgia. You don't necessarily have to say, I was lifting that box over there and I felt a back strain when I lifted it. It could be as simple as later on through the day telling the, after unloading a truck, telling the employer, man, my back is killing me after, well, you don't even have to say unloading the truck. Then it's put to the burden is put on the employer to then ask, well, why is your back killing you? And then you can say unload the truck. So the notice requirement is pretty loose, and the notice or reporting requirement is pretty loose. But the problem is that if you waited, your supervisor may develop amnesia when you come back later on and say, do you remember me telling you about my back pain? And he may go, no. I talk to a lot of people all day long. They don't tell me. I don't listen to or keep up with, minor complaints. So if you don't be more specific, you risk the supervisor saying you didn't give them notice. Okay.
Okay. And that makes a lot of sense. So that actually leads into the next question, which is, when should you request to see a doctor, and does it affect anything if you don't request within a time limit?
Well, once you provide notice to the employer, typically they will ask you if you feel like you need to see a doctor, and if you don't need to see a doctor, you don't have to go see a doctor. And a lot of times the employers, especially the larger employers, will have drug screenings that they do, and so they'll send you to one of their doctors to take a drug test if you report an injury. But in Georgia, if you do need to see a doctor, the employer is supposed to have what is known as a posted panel of physicians, and you are able to go to that posted panel and choose. In fact, it's your choice. It's not the employer's choice. They're supposed to list 6 doctors on there that you can see, and it's your choice of which of those 6 to see.
Okay. Great. And I had another question that I just lost. Oh, I know what it was. So if you request to see a doctor, you mentioned in there that sometimes larger companies have doctors that they send to you. That raises a question in my mind, and it wasn't in our notes, so I don't mean to sideswipe you with this one, but if they're sending a doctor to me, should I talk to you first? Or am I okay to see their doctor without talking to an attorney?
Well, the doctors that are on the posted panel, those are all doctors that have been hand-chosen by the insurance company to begin with. Okay, so those doctors are already in the employer insurance company's corner. So, just because you talk to an attorney, the answer to that question would be yes, you should talk to me first if you can. And the reason is because those are company doctors that are on that list. And one of the things that I would do if we have enough time in between the company sending you to the doctor, I would ask that you get a copy of that posted panel. And a lot of times now, everybody, a lot of people have iPhones or cell phones that take pictures. And I have people take a number of pictures and then send those pictures, email those pictures to me. And I can tell, first of all, if let's say the panel is valid, and we'll talk about what a valid panel is in a second. But if the panel is valid and we have to choose one of those doctors, a lot of times I will know which of those 6 doctors is the best doctor to choose for you. And it's usually not, one doctor's a great doctor. It's usually that I know 3 of the other doctors are so bad or so, against the employee that I wouldn't want you to go there. And so it's a kind of a process of elimination. The second thing that I can do is many times the panel is not valid because maybe out of the 6, maybe one of the doctors has stopped taking workers' comp, or maybe he's retired. And if the panel is not valid for some reason, then you can choose any doctor that you want to see. And I have doctors I know that are good doctors that I could recommend to you. So that's why you would want to talk to me, and you wouldn't have to necessarily disclose to the employer that you've talked to an attorney ahead of time, but at least you would know what your rights are then.
Exactly. Well, that's great information. Our next question is dealing with the paperwork. So when should you complete the paperwork? When should you fill out the claims form? And I assume it's within that 30 days, but is there a process that you need to go through to make that work properly?
Yeah, there's no specific requirement under Georgia workers' comp law that you have to fill out a particular type of claim form. I mean, many times, the employers will have their own, what you call an incident report or something, and they will want the employee to fill it out. And because they want to get, at every turn, they want to get the employee telling their version or saying what body parts are injured, mainly so that later on you can't deviate from that, So it's usually going to be the employer forcing the employee to fill out some of these incident reports or forms. And for example, one of the problems that I see sometimes is that if the employee doesn't, accurately or fully describe, it might say, give me the description of what happened. If they don't fully and accurately describe what happened, and they say, oh, well, you didn't tell us about these other facts. Oh, there's only so much room on this claim form that you gave me. That's why I didn't tell you about the other facts. So that is sometimes a problem. And the other problems that I sometimes see on these incident report type forms are when the employer says, what did you hurt? Well, if the guy, fell off a 10-foot ladder, broke his back, and also had a knee sprain, more than likely the guy's going to say, I hurt my back. He's going to list the body part that was injured the worst, when in fact he may also need knee surgery later on as well. And so what I would tell an injured employee, be sure that you fully and accurately describe what happened, and also list all body parts, no matter how that are injured, no matter how minor the injury might seem at the time. And if I can just talk one more thing about this.
Sure.
When you say claim forms, I am distinguishing an incident report from the other type of claim form, which is the official board form, which is the WC-14. Now, a WC-14 is a form that you have to fill that out within 1 year of the date of injury. I mean, that's the general statute of limitations. Without a lot of time to talk about statute of limitations, I don't want to say that is the only way, there's only 1 year, because there are exceptions to that. But in general, you would want to, if you had a medical-only claim that was going on, you would want to go ahead, and sometimes before the year is up, which is a long time, but you would need to know, if you're not an attorney, you don't know that you need to file that form within a year. And so I would just distinguish that type of claim form.
Great. That sounds great. All right. Well, and then what was that? Talking about the claim forms, you mentioned an actual form. Now, you as a workman's compensation attorney, if they're working with you, do you fill that out for them?
Oh yeah, I take care of all of that. I am able to pull up the forms and file them online with the state board, and instantly see all the forms that have been filed in the state board's file. So yes, if I'm representing a person, I handle all the issues, including filing of those forms.
Great. And then the other thing that you mentioned is how to be as detailed as possible with explaining your injury and even if it's minor. A question that I've seen, because as I've researched some of this to get ready for talking with you, I've also seen some people advise be as vague as possible so that the attorney can decide what's relevant. Would you suggest being vague and being as detailed?
Yeah, there are two schools of thought there. And the thing is, if you are going to start talking about specifics in your case, then you just need to be sure that you flesh it out completely. If you are, if the employer is not going to ask more, then that is, as far as the description of the accident, that that can be an option of how to complete that type of form as well. I mean, if you fell off the roof, you can just put fell from the ladder. In other words, it's fine to be vague and simplistic, but if they start questioning you and having you put details in, you got to just be careful that you are able to fill out, to verbalize what it is. And frankly, a lot of some of the workers that I deal with are blue collar workers who may not have the ability to write 3 paragraphs about how their injury occurred in great detail. So the injured worker needs to do one or the other. Either they need to be vague but accurate, or if they're going into detail, they need to be sure that what they're saying cannot be taken 2 ways.
That makes sense. Thanks for clarifying that. Ladies and gentlemen, we've been talking with Zack Hendon on workman's compensation law and what you should do if injured. Zack Hendon is an attorney here in Metro Atlanta with the Hendon Law Firm. And if you're in the Metro Atlanta area and you need help, be sure to give him a call at 770-284-3737.